right, Will Worsham joins us now for this week's Speaking Legal discussion where he answers a viewer's legal question on air. Let's take a look at today's question. My husband and I keep our finances completely separate because we have very different credit scores. If one of us dies, though, will the other person inherit the debt, or are we safe by not having any joint accounts?
Interesting question.
Yeah, that's actually a really great question. I like it. Here's the thing. You're not liable on anybody's debts that you don't agree to be liable on. So, you know, if you have credit cards that you've taken out that your spouse is not on there as a co-signer on the account, then your spouse is not going to be liable for those debts, and vice versa. And that can even go, even if you have given them a card on your account where they can charge on your account, if they've not agreed to be liable on that account, then they're not going to be liable for it. You can't inherit debt. It doesn't work like that.
Where does the agreement to be liable come in? Is that when you first sign up for the card?
Sure, that's where you know the credit application, and it can be as innocuous as even when you sign up, it says, hey, do you want to include your spouse's income on this? You put your spouse's social security number down, and then they sign off on the application. Usually, if they're going to consider your spouse's income as part of the consideration for granting the line of credit, then your spouse is also going to be liable for the debt.
Yeah, but so often it's just, it's that, do you want to let such and such, do you have someone you want to allow to use it? They're free.
Yeah, and it works both, you know, you see both of those on there. There's co-applicants, and then there's somebody that can have an additional card. You also can get in this scenario, and we've just been talking about credit card debt, but you talk about some other type of debts. Car loans, sometimes you'll have a co-signer.
Yes.
You know, they're not making payments, and they think that it's okay, but the whole point of having a co-signer, if the bank comes and says, oh, we'll be happy to extend you the credit, we'll be happy to give you the loan, we just need you to have a co-signer. Well, what that really means is they're not confident enough in you and your own credit score and your own credit history to pay back that debt, so they've asked for a co-signer. If you co-sign a debt, you are fully liable for that debt, just as the original debtor is. So a lot of times parents will co-sign for student loans. In fact, we've seen some of this in the news recently. Parents co-sign for student loans so that their child can go to college and get a student loan.
You're taking that debt on.
If the student doesn't repay the debt for whatever reason, or in the case of a couple news articles, the death of the student, and then the student loan company comes back to the parent, the co-signer, and says, you've got to pay this debt. Of course, that's a tragic situation. It's obviously a double blow, the death of the child, and then being liable for their debt because you co-signed their student loan.
So what do you do? Getting back to the question, keep it separate?
Yeah, if you don't want to be liable for your spouse's debts, then don't co-sign on the loan. Don't be a co-applicant on the credit card. So the husband can have their own credit cards, the wife can have their own credit cards, and they're the only ones obligated on those cards.
Can the card go to a person's estate, though?
Well, that would be the situation. That's exactly the right answer there, is the debt would still attach to the estate. So if there are any assets in the estate, then the credit card company, the creditor could come against the estate, file a claim with the estate and say, I need to be paid before the assets are distributed. So you can't inherit the debt, you can't become liable for it, but if that person has assets that get distributed in an estate, it has to go to pay those debts.
Well, if you are in a relationship with someone who tends to spend, I suppose it would be in your best interest to say, yes, I'd like to have this Visa or MasterCard. I would like for you to be a co-applicant. Then how do you divide it up at the end if the marriage dissolves?
Well, yeah, now we're getting to divorce questions. And even if they are separate accounts, in a divorce situation, it would be considered marital debt. And it would still be divided amongst both spouses, even if they weren't a co-signer on the loan or the credit card application.
Really?
Oh, it would be?
It would be. It's an equitable division of, in a divorce situation, which is not the question, but in a divorce situation, it is an equitable distribution of the assets and debts of the marriage. And so even if...
That surprises me, kind of.
Well, and it catches a lot of people by surprise sometimes. But no, if it's a debt is incurred during the marriage, just like if income is incurred or obtained during the marriage, it's a marital asset, it's a marital debt, and it gets divided as a part of the divorce.
I'll be darned, I did not know that. Well, if you have a legal question for Will, we do. This is interesting. Email him at wworsham@color10.com, and he'll answer your question on the show. And coming up